morning. I can now see that there are lots of people who are having some technical issues. I'm not sure if you were getting that feed through or not, but we're going to kick off again for those who were watching it. For those who weren't, welcome. So good morning and welcome. We are going to be talking today about estate administration, although I can't see my colleague Helen who is actually presenting, so we are having some technical issues this morning. For starters, I'll let you know that our workshop for the second half of this year, based on your feedback to us, will be on next month. About 4 weeks, you would have got 1 month reminders if you've Victoria together. So there are separate days based on the different legislation in those different states. So there will be, I guess, if you haven't signed up, please do. It's a 2-hour session, and it's based on your feedback to us earlier this year. And so I will let you know you can download today's slides, which I've just made available for you, and they will obviously show up on the screen as well as we work our way through this presentation. Given my colleague Helen is not on at present, I might kick off and take it away. So we're going to be going through today the estate administration, which is the final of our estate planning series. We have run 7 of them to date, and this culminates in estate administration. So what we're going to look at is the legal consequences of when a person passes away. We're going to look at the various differences where a person dies without a will and what the rules of intestacy talk about. And we're going to talk also about where a deceased had a valid will. We're also going to look at dealing with inter vivos trusts and the appointment of successor principals. We're going to touch briefly on disputes and family provision applications, and also the taxation consequences of death. Although I would point you to our webinar in the last series, number 6, which is on our website, under the Solutions in Action page, which goes into more detail in relation to the tax consequences. So when a person dies without a will, this is what's called intestacy. It's a word that's difficult to say, and it can be embarrassing if you get it wrong. But essentially, if you die without a will, you are subject to the laws of intestacy. They are different in each state and territory around the country. And generally, your next of kin will apply for what are known as letters of administration. So basically, the job is much the same as in probate, and that is to administer the estate, which includes gathering in all of the assets, paying out debts, and distributing the estate in accordance with the intestacy rules. So in terms of intestacy in Queensland, as I said, they are different in each state, and in Queensland currently, if you have no children, all of the deceased spouse's estate will go to the spouse. If there are children, the spouse will receive the first $150,000 of the estate, plus any household chattels. And from there, if the child survives, if one child survives the deceased, half of the estate goes to the spouse and the other half to the child. If 2 or more survive, then 1/3 of the estate goes to the spouse, and 2/3 go to the other children. So you can see it can often have some interesting outcomes where a person may think that if their spouse were to pass away, then they might receive all of that person's estate, when suddenly some of their assets that they they might own as tenants in common, for example. Suddenly they own that asset with their children, or perhaps their spouse's children. So it can lead to some interesting consequences. Where the person does not have a spouse, the whole estate is distributed to the parents, and then there's a cascading effect. So if there are no parents, then obviously siblings. If there are no siblings, no parents, then it's nephews and nieces, and so on and so forth. Obviously, if there is no spouse and there are children, all of it will go to the children. New South Wales, again, if there is a spouse but no children, then all of the estate will go to the spouse. Where there are no children, with the spouse, then all to the spouse. Subsequently, where there are one or more children, the spouse will take, again, those personal effects. The monetary amount that they receive is higher than in Queensland. You receive $350,000 with some increases along with CPI, and half of the balance of the estate, and then the children take the other half. In terms of where there is no spouse, the provisions are the same as Queensland. Essentially, that cascading order where it goes through the family or all to the children. Victoria, again, there are differences. If there is a spouse and no children, all of the estate will go to the spouse. Where there are children, if the estate is worth less than $100,000, then all of the estate goes to the spouse. If it is greater, they receive $100,000 bequest, and then a third of the balance estate, and then 2/3 is shared amongst the children. Again, if there's no spouse and no children, the order is the same, and then if there are children, it's the same as the other states. Moving to WA, which from the slide has slightly more complicated provisions and somewhat mirrors with some differences what the law in certainly Queensland used to be before at least 2013, where even if there is a spouse and no children, where the estate is greater than less than 75,000, then all of the estate goes to the spouse. Where it's greater than $75,000, the spouse will get $75,000 and half of the household chattels and half of the estate. Then the other half goes amongst parents, receive the first $6,000, and then there's some further complicating rules, which I won't read through in full detail, but you can kind of see that unfortunately for probate lawyers in Western Australia, there is a fairly complicated set of, not necessarily complicated, but there's certainly a process that you need to follow to determine who the correct person to receive a share of the estate is. If there are children, again, there's fairly significant differences to the other states. So again, if it's less than $50,000, all of that estate will go to the spouse. Again, if it's greater than $50,000, 1/3 of the residue will go to the spouse and 2/3 amongst the children. So probably in WA has the, I guess, greatest amount of difference from what a person might think their estate would look like if they died, if they didn't have a will. Most people would think, if I die, my spouse will get everything. And unfortunately, that isn't necessarily the case in any of the states. So what happens if you get to the bottom of that matrix and there's no one to receive your estate? Well, essentially, the state or territory government receives all of your assets. In the Northern Territory, there are some exceptions. So Northern Territory, Tasmania, and New South Wales. and if the person identified with a particular Indigenous group or community. There are some exceptions there. On application to a court, the deceased estate can be distributed amongst that group in accordance with that group's customs and laws. So looking at the, I guess, traditional owner groups and their customs. So obviously the issue with intestacy is that it's very unlikely that it will match the testator's wishes. If their assets are in different jurisdictions, it can also lead to having to obtain letters of administration in each state, which has different distribution rules. And obviously it can lead to situations where assets may be owned by a number of different people and not necessarily in a convenient way for perhaps the sole surviving or the surviving spouse. Stepchildren are considered children at law, so they will rank equally with non-stepchildren, and children become entitled to inherit at the age of 18. The short answer is let's avoid intestacy by leaving a will in place. And I saw a stat the other day which said that 77% of Australians don't currently have a will, which is a frightening statistic, and frankly just leaves their family with a significant headache's the wrong word, but you get what I'm saying. They have to then work through this matrix instead of saying, here's the will, this is what mum or dad wanted for their assets, leaving aside family provision claims. But essentially, a will leaves a fairly straightforward, streamlined approach to dealing with a person's estate. So when we review any will, when clients come to us saying, they have a will previously and they want to update it, or even if we're reviewing the will after a person has died, the first step is the will valid? The rules in all the states say that a will must be signed by the testator. It must be witnessed by 2 individuals who are over 18, and they must not be beneficiaries under the will. Now, there are some limited exceptions, but it's preferable that they are not witnesses, that the witnesses are not beneficiaries. It must be dated. Now, the witnesses don't need to know the contents of the will. You don't need to explain, who you're giving away your assets to after your death to those witnesses. For example, in these COVID times where lawyers might send a will rather than have you come into the office to sign it, you might get, 2 neighbours to come and sign. Now, they don't need to understand that, who you're giving your assets to, but they do need to understand that what you're signing is a will, and understand, I guess, the significance of that. So the steps when a person has passed away and we're looking to get a grant of probate or understand what we have to do as executors, well, the first step is who are the executors? Identifying them and seeing if they are willing to take up that role. And then who are the beneficiaries under the will, and are they still alive, for example? Where do they live? Those basic steps. Are there specific gifts made under the will, and are those gifts capable of being made? For example, they haven't sold an asset, which happens regularly, and what is the effect of that? Are there testamentary trusts established under the will, and who are the trustees of those trusts, and identifying those people and obviously reaching out to them. So the roles, we have been through this in this course, but it's always important to understand in estate administration what the different roles are. So we've got the testator being the person who makes a will. Generally, they are only a person over 18 years old can make a will. There are the ability to go to court and get a will written for people who are under 18. There are provisions there, but generally a person over 18 is the only person able to make a will. The trustee, like a trustee of a discretionary trust, for example, holds assets for the benefit of beneficiaries. Now, there are two roles, obviously, in an estate. There is an executor and a trustee. They do have slightly different roles. Often they are merged into the one person. So you might be the executor of an estate, and your role is to collect in assets, pay debts, and administer the estate. But at the same time, those assets might be a business that the person operated. And you, in the capacity as trustee for those assets, might need to sell the business, for example, and move to an orderly transition there. So they're often merged in the same person, and certainly our wills do that because it makes it a whole lot easier. But they are different roles. Beneficiaries, obviously people who receive an asset from the estate. Now that might be an individual person, or it might be testamentary trusts, or even inter vivos trusts who might receive assets, and guardians. So if, in my circumstance, I've got 3 children, all under the age of 13. So I need to make provision in my will as to who I want to look after my children if both me and my wife pass away. That generally leads to many discussions between the people as to finding that suitable person, and that changes over time. It's certainly changed for me as my family circumstances have changed, just in the fact that the person who I originally nominated, my sister, she had 3 children of her own. To give her my 3 boys would be a nightmare for her. So we had to rethink that position. So these things are static and not static. They're dynamic. They constantly change, and you need to give constant thought to all of these roles. So as I said earlier, the executor's role is to administer the estate. In theory, they organise the funeral. That is the case if it's family. If, for example, it's not a family member, oftentimes an executor might come in at a time when that's already been organised. They will generally call in all the assets of the estate. They'll pay for the funeral, or they may reimburse the family member who has paid for the funeral. They'll obtain a death certificate. Generally, the funeral home will take care of that for you and send it on. But their job is to essentially collect all the assets, pay any debts that can be paid. If there's mortgage repayments that need to be made, if there's not a direct debit type feature, well, that they'll take care of those payments from the estate assets. But essentially, they will administer it as if the person were alive, and take over their liabilities until they can fully administer that estate. Often we get a question of whether the executor can charge for their time. You as an advisor might be as an executor of your client's will, as I am for a number of our clients. The short answer is yes. The will generally permit an executor to charge their time, and also the law allows for it as well. Oftentimes where an advisor like yourself might be in that role, we provide certain, express provisions in there that you are able to charge for your time in administering the will. That's probably different to if you were lodging a tax return for the estate. Well, you as the executor or co-executor would appoint your firm to prepare tax returns. Well, that's a separate engagement to being paid as an executor. But both of those are obviously allowable. Obviously, under a will, there is a high degree of responsibility placed on the executor, and sadly, it comes at a time when people in families might be at their worst, unfortunately. You know, their loved one has died, or even a person who's not a loved one, unfortunately, has died. There'll be people coming to, you know, with their hand out, unfortunately, wanting their share of the estate. Often it does bring out the worst in families. And it is important to have an executor who, one, understands their role and the responsibility, and has, I guess, a little bit of strength to be able to manage the conflict that can naturally arise after someone has died. And that's even before we talk about a beneficiary making a claim on the estate. But what if you're nominated as an executor and you discover that, or you didn't know, and you discover when the will's pulled out that you're the listed executor and you don't want the role? Well, obviously you can't be forced to take on that role. You can renounce. You can appoint a solicitor to act on your behalf. That's generally where you are technically the executor, but they do the work for you. Or you can simply renounce the role and someone else can take up the position. So really the first step in your job as an executor is to identify what they owned. Obviously, leaving aside the legalities of becoming appointed as the court-appointed executor under a probate application, your real job is to say, well, what are the assets that were owned by the deceased? And the things we look for, obviously, the easy stuff: real estate, cars, cash. Finding bank accounts can be difficult, but obviously, you know, people will generally have bank statements in their home, although probably in 20 or 30 years it will become a bit more difficult because we'll be less reliant on paper in the future. Shares, obviously we can conduct searches for those sorts of things, and identifying businesses and you know, business assets that might be in the person's name, or trusts that they might have controlled prior to their death. Again, life insurance policies, partnerships, if they're in a partnership, any foreign assets, which can be very difficult for executors to manage and, I guess, administer. Nursing home bonds, so you might have a return bond after the person has passed away in a nursing home. Then we need to identify out of those assets, and oftentimes it's more common in real estate assets than other types of assets. Well, how are those assets held? Were they held as joint tenants or as tenants in common? Obviously, the significance of those two is that as joint tenant assets, it doesn't actually form part of the person's estate or is dealt with under their will. It automatically vests in the other joint tenant, whereas tenants in common, that asset forms part of the estate and has to be administered in accordance with the will. Liabilities. So do they have a mortgage on their home? Do they have any personal loans, credit cards, you know, accounts with anyone? Because the executor will have to, in administering the estate, they'll have to go through and pay out those debts. So it's critical that we identify them, get on top of any payments that haven't been made or that need to be made, so that we don't cause any issues for the executor themselves and also for beneficiaries going forward. Have we got any liabilities that have, you know, come up that have been paid by other people? You know, do they have a funeral expense bill that a family member has paid for, which is often the case? We'll repay those expenses. Sometimes, obviously, it's a prepaid funeral, but there may be some top-up payments to be made. Did they have litigation? You know, were they being sued at the time of their death? Now, death doesn't automatically terminate that lawsuit, and decisions about that will have to be made as to what steps are taken going forward, and that can become quite complex. And income tax liability. just because a person has died doesn't mean that negates their liability to income tax for, wages they earned prior to their death. How do we deal with those? Or, the executor needs to deal with those in terms of lodging tax returns and getting what once were group certificates. It's probably all online now with single touch payroll, but they're things that we have to deal with as an executor. So if the will exists, do we actually need probate? That's usually the first question that comes to mind. Probate is the term for submitting the will along with a number of other documents, some affidavits and the like, essentially saying or proving that this is the last will and testament of the deceased. And also that the executor named in the will is the person applying for the grant, and proving that there's no reason why the grant should not be given to that person. So there's no limiting. There's some rules in the Succession Act which say, well, if you're bankrupt, for example, you shouldn't be an executor. So those forms go to the Supreme Court, and the Supreme Court will, in effect, rubber stamp, provided they're happy with all the requirements being met, and provide power to the executor to administer the will. Now that gives the executor some, I guess, protection from liability if they administer the will according to the will and in accordance with some certain timeframes. It gives them protection in those circumstances where if you don't obtain a probate the executor doesn't have that same protection. So the first step really is identify what are the assets of the estate, what's the value of the estate that we're dealing with. If we're talking about a low value estate with no real estate, no banks to deal with, then oftentimes an estate might be administered without a probate application being made. A probate application will cost legal fees between probably $3,000 to $5,000, probably closer to $5,000 in terms of, I guess, costs for professional fees, the cost of the court application, and some advertising that goes along with it. So if we're talking about an estate that's worth $10,000, well, obviously the costs outweigh the benefit. If we're talking about an estate that has a bank account, for example, that might have $200,000 because that's where the bond from the retirement home has gone into, most banks won't release that money unless probate has been obtained. So oftentimes, whether or not probate is obtained is dictated to us rather than it being, I guess, a choice. I can see we've got a couple of questions coming through. The question is, are publicly listed shares held jointly, automatically, or held? Are publicly listed shares held as joint tenants automatically or as tenants in common? The presumption is generally that they are held under a joint tenancy relationship rather than tenants in common. So oftentimes that is, essentially joint tenancy is the preferred outcome there. So you would have to do some step to break that tenancy. You can certainly do it with real property, and you can record it on the register as tenants in common, not necessarily on the CHESS register, for example. Thanks, Rob. So if you do have any other questions as we go along, please feel free to jump in the chat section and put them in, and I'll try to get to them. So again, I think I covered most of that slide. Probably the top point there, one of the biggest things with most people when they're dealing with death and estates is they want They want it done yesterday. They want everything wrapped up. Their father has died. They oftentimes will get a phone call the day of or even the day after saying, "Oh, Dad just died. I need to get the will sorted." And there is a real tendency to want to be doing things, oftentimes it's our job to say we need to slow down. We need to take time. An executor should not administer the estate before 6 months. And there's a rule for that, there's a reason for that, and that is that under the Succession Acts, and there are different timings in every state as to when this time frame starts. So I'll go with Queensland because I know it best. So in Queensland, if an executor administers the estate inside of 6 months, they become personally liable if someone makes a claim. Might even just be a creditor that came forward, or it may be someone making a family provision claim. So they become personally liable for, the assets or the asset value that they've administered. So if I was an executor and I distributed the bank account because that was the only asset, it was worth $500,000, and a family provision claim was made and it became successful, then I would be personally liable in order to fund whatever that claim is up to that amount of that $500,000. So that's a fairly significant impost on the executor. So that's why we say the estate should not be administered until that time frame is hit. I know that in New South Wales, there are different timings as to essentially when that time frame starts. So in Queensland, it starts from the date of death. New South Wales, it starts from when probate is issued. So it pays to, and I'm sorry, I don't know the other states off the top of my head, but it pays to understand when we should be administering those estates, because the financial downside to it is great. So again, if the will exists, it may appoint principals or appointers of trusts, and our trust deeds will have a clause that says, if permitted by the trust deed and no one else is appointed to this role, I appoint either the executor or the trustee of a testamentary trust to take over control of that trust. Most trustees will say that role will fall to the legal personal representative if there's no one else appointed to the role. Certainly our deeds say that. So the legal personal representative might then appoint a beneficiary as the principal of that trust, or they might appoint themselves. That would then allow them to take control of that trust and obviously continue the business that might continue on, and I guess allow for a succession of control of that trust. So family provision claims, we've dealt with these quite extenstively in another paper given earlier, but essentially it's where an eligible person makes an application to the court that adequate provision for them has not been made from the deceased. Generally, in Queensland, you must make your claim at least. You must give your notice of intention to make a claim within 6 months of the date of death, and you must apply to the court within at least 9 months. Obviously, there are some extensions to that possible, but you'd need leave of the court. But that is really how the mechanics of that work in practice is that as an executor, you'll get notice of a claim, a potential claim being made, and that will generally come before that 6 month mark. And you'll then enter into some negotiations with, with that claimant and try to flesh out, well, what is your claim? Do we think it has merit? And hopefully you might get a deal in that 6 to 9 month period. That doesn't always happen. In practice, you might agree that if you can't do a deal, you might agree that if they apply after 9 months, you won't object, and that you'll even consent to the time being extended, just to allow you to, I guess, negotiate a bit more. But if not, unfortunately, it may end up going to court, and it's a bit loose to say that the estate will pay both sides, but that tends to be how it works out in the wash. If the person is successful, it's probably more probable that the estate will pay the legal costs of that successful applicant. So you can kind of see probably where I'm going, that this has become a fertile ground for people to challenge, because lawyers will take this work for no win, no fee type activity. We don't, but there are certainly plenty out there who do, because they know that if they've got a claim that has merit, the estate will often pay certainly a proportion of their costs. I can see another question coming through. Thank you for that. Valuation of business assets as part of an estate. Must the will include guidance on the valuation method, or is the Act a guide? So short answer is, generally I've never seen a will that provides guidance on valuation method. Sorry, that is not completely accurate. I have actually written them into wills, but they're the 1% or even less than 1% of wills. They don't generally provide a methodology for valuation of business assets. We would generally be talking here about business assets that are held in the person's name, because obviously under a will, person can't gift company assets or can't gift trust assets. But you might say, well, I'm going to place beneficiary A in charge of this trust, and therefore by doing that, they're getting that trust. And because of that, I want you to value those business assets or those trust assets, and then make an equivalent gift from my estate to my other child, beneficiary B, of that equal value, so that essentially they're trying to even out that gift, and then split the estate equally amongst those two children after that gift is made. And I've certainly done that in the context of some families around from Sydney, is the one that jumps to mind. So in that case, we did say, well, the assets in those trusts were real estate, so we wanted a valuer from a particular, not a firm, but an industry, who's registered with a particular industry body down there, to go and value those assets, so that we could make those gifts somewhat equal. So generally, a will doesn't provide that, but it can. Thanks for the question. So I'm going to try to get through these. In terms of family provision, who's eligible? It really does vary, but fairly generally, it will obviously include a spouse and de facto, children, including stepchildren, and a person who has had a dependent relationship with the deceased. So it might not be a child, it might be a nephew, for example, who the deceased was the guardian of, and they lived with that person. Well, that person is obviously in a dependent relationship. If they haven't been provided for, they may have some claim under the will. In terms of family provision claims and its effect on the administration, essentially, while a family provision claim is on foot, no administration of the estate will happen. So when I say that, no distribution of assets will happen. And that's because we don't know what a court might say as to what the proper distribution of the estate will be. It may be that a court says, actually, the will is going to be modified and this is the distribution that's going to happen. Well, if we've distributed assets, then obviously we've given away those assets that are going to be, the distribution method's going to be changed. So Essentially, an executor is just going to hold ground, do nothing, deal with the claim that's made, and once that is determined by settlement or by adjudication of a court, they will then go about administering the estate. Obviously, again, I said earlier, if they distribute early before that claim is finalised, they can be personally liable. Again, I mentioned this, estate often pays the claim, but it does depend on who wins in the fight. If I'm a claimant on an estate and I lose, I will generally be made to pay my own costs. In New South Wales, they also have what's called a notional estate, and that is where I give away assets, sometimes for the reason of divesting my estate, so that a beneficiary might not be able to make a claim. Well, those assets could be drawn back into my estate, and it becomes particularly relevant in the context of trusts and trust assets. And you have to structure your trusts. If you want them to be outside a notional estate claim, then you need to structure them in a particular way, making sure that the deceased doesn't have the sole ability to draw back assets into their estate. So CGT on death of an individual, we're going to talk about, I guess, just a couple of things. Obviously, there are exemptions under both transfer duty laws and CGT laws. In terms of the cost base of assets, if we've got a pre-CGT asset in the hands of the testator, then that asset will receive a market value cost base at the date of death. That's fairly well understood. Obviously, the beneficiary inherits that market value. If it's a post-CGT asset, the beneficiary inherits the cost base. So when they ultimately sell it, it receives the cost base of the deceased. There are obviously some concessions where an executor, for example, disposes of assets within 2 years of the date of death. Essentially, if it's a main residence or a small business concession might have applied to the individual. If the executor deals with that asset within 2 years, those concessions will still apply as if they applied to the testator. Dwellings, like I said, yep. If you resided in the dwelling, you sell it, the executor will retain your, I guess, concessional status. I think I covered all of that in a couple of other slides. In terms of probably one area that causes a little bit of an issue is sometimes where a spouse might inherit, I guess, a life tenancy. There can be some complicated matters around life tenancies and how they might end. Oftentimes they are the subject of dispute. So it is probably one of the areas that needs a bit of care when crafting a will, because where we have a life tenancy to the spouse, for example, the assets are then once that spouse either passes away or perhaps moves out of the house, then the residual beneficiaries then have the ability to take that asset. And that's probably where a lot of the fights come in, is the wording of that life tenancy as to whether the spouse might need to downsize the house or move into retirement home. Well, does the will provide for that? Oftentimes you'll see disputes arise where the will says can reside in, has a life tenancy to reside there, whilst they're alive. That's it. Well, if they move out, what's the consequence of that? Oftentimes it's not necessarily a problem because there are children involved and children will want to look after mum, for example, but that's not always the case, and that has been a constant source of dispute in cases before the courts in this area. So it's something to make sure we understand what the ramifications of a life tenancy and to craft that well in our will. So that's, I guess that's the paper today. Again, I do apologise for all the technical issues. It looks like everyone was managing to get on here. We did start over on, I don't know where it was, but we didn't have any attendees and Helen started talking. She hasn't been able to get on today and I got thrust into the speaker's chair. So I hope you took some value away from that. If you've got any other questions, I'm happy to hang around for a few minutes. Obviously, you can punch them in anyway, and they will come through, and we'll try to respond to you separately on email if we can't get you online. There will be some feedback surveys coming out this afternoon. Please fill them in as best you can. They literally take you 30 seconds to fill out and gives us an indication of what you thought of today and any other topics you want to talk about. If you haven't signed up for our workshop next month, please do. It's 2 hours. It's got some great content, and the content is all based on your feedback that you gave us in some surveys earlier, probably 2 months ago now. So there's some good topics there, and it is 2 hours, so it'll be 4 speakers for half an hour each, and it will be a great session. So if you haven't got any other questions, I'll leave it there for today, and we'll catch you next time. Thank you.